Thank you everyone for joining us. Our panelists here today are Roshan Mansinghani of Unified Patents, Jeremy Albright of Norton Rose and Fulbright, and Patrick Richards of Munch Shellist. My name is David Tobin of McDermott, Will and Schulte. Our bios are at the end of the presentation. About the slides, we'll try to call your attention to slides relevant to what we're talking about. So you can take notes if you like, but if you're just listening and not watching this webinar, that's not a problem. You'll be just fine. The slides are not critical. Last thing before we begin, slide 5 contains a disclaimer. Basically, you are not our clients. We are not your lawyers. What we do here today is for general education and not for you to act on without appropriate advice. So let's get to it. With reference slide 11, our intro slide here, question for you, Roshan. Are PTAB trials usually standalone, or are they usually part of a broader litigation?
So PTAB trials are typically part of district court litigation. When the inter partes review statute enabling this was passed in 2011 and 2012, all of the conversation in Congress and the lobbying for it, if you look at the legislative history, all imagined that this was going to be a less expensive alternative to addressing sort of the subset of issues regarding validity and only a subset of those issues in front of the Patent Office, as that was imagined to be sort of a more efficient way of handling those issues. On top of that, you can see that in the statutory framework. So, for example, the estoppel statute, which we'll talk about later, sort of contemplates that the petitioner can't use certain arguments in co-pending or district court litigation that come afterwards. And then finally, I got the opportunity to write an article on this issue, kind of looking at the numbers, and the basic numbers are between 80 to 90% of patents that are challenged in PTAB trials are involved in co-pending litigation. Sort of one lesser known stat that we got to elucidate in that article was that doesn't mean that the same applies the other way. So it turns out that only about 10% of patents actually asserted in district court litigation end up getting into a PTAB trial. So it's not that patent owners, for example, are constantly facing these two forums, but in the PTAB trials, the chances are high that if there's a patent challenge, it's involved in a district court litigation, and it sort of makes sense because these challenges are fairly expensive. They can cost hundreds of thousands of dollars to prepare, and the filing fees alone are close to $50,000 at this point. So for that amount of money, it really does make sense that there has to be more at stake than simply just a concern about a potentially invalid patent.
Thank you. Patrick, let's turn to you. Is there any overlap in terms of the kinds of issues that are handled at the PTAB and in a co-pending U.S. District Court litigation?
Sure. And as Roshan had just mentioned, the primary intent of the PTAB trials was to deal with invalidity at the PTAB instead of at the district court. So there's a few ways in which these trials overlap. For example, subject to limitations that we'll discuss further in the presentation, discovery can be shared between the district court litigation and the PTAB. Part of the goal here is efficiency, and duplicating the process is not necessarily efficient. So there are some mechanisms for sharing discovery. Over time, this was not true initially when IPRs were first brought into play, but the claim construction analysis is identical now at the district court litigation and at the PTAB. They're both following the Phillips standard. There's different standards of review at each, right? The district court litigation starts with the presumption of validity for patents. That's not true at the PTAB, where they're reviews de novo, and they're essentially just looking, for preponderance of evidence there. But there is overlap in how the validity analysis goes, and obviously, more importantly, an invalidity finding at a post-grant trial is going to substantially impact the district court litigation. wiping out that patent. The last point I'd make about the overlap between the two is the arguments that are made in one can create estoppel in the other. Amendments made or arguments made at the PTAB can create prosecution history estoppel for the co-pending or future district court litigation. So you need to be mindful of both trials when making arguments in either.
Great. So by way of current events, on October 17th, the director of the United States Patent Trademark Office sent a memo to all the PTAB judges saying that going forward, excuse me, the director himself will determine whether or not to institute a trial on IPR and PGR proceedings. And again, this happens at the 6-month window from filing. Previously, this was a task for panels of 3 judges, but on October 17th, the director again said that he himself would be undertaking this task. And he provided some other information as well. In view of and Jeremy, turning to you now, in view of this October 17th memo and some of the recent discretionary denial considerations over the last few months, when should one consider filing a petition when there's a parallel district court action?
Yeah, thanks, David. At the outset, I would say the considerations or the times when a petition makes sense are much less now. I think discretionary denial has become a huge issue, and it limits the situations in which filing a petition makes sense. I think one of the primary considerations that we can take away from some of the recent discretionary denial decisions is timing. The final written decision in any IPR that is requested needs to issue before the district court trial date. So IPRs, you file an IPR, it takes a little over 18 months to reach final written decision, whereas a fast district court can reach trial within, depending on the court, as an example, let's say 24 months. And with that, in that situation, you would need to be on file with your IPR within 6 months of the complaint, and ideally even before that. So one of the considerations is, when is that trial date? You also are going to need to move fast with your IPR petition in order to beat it. And I think other considerations that are coming out from these discretionary denial decisions and some of the proposed rules that have been submitted for notice and comment, I think you need to be willing to enter a strong stipulation to not pursue 102 or 103. That's anticipation or obviousness. Those are the grounds available in an IPR at the district court. And notably, stipulations have been a thing. The prevailing stipulation was that you wouldn't pursue any grounds you could have pursued in the IPR once it concludes with a final written decision at the district court. I think now the stipulation needs to be, I'm not going to pursue anticipation or obviousness at all, to include system art, not just patents and printed publications. So that's a really, really strong stipulation, and a petitioner's willingness to make it, I think, is definitely a consideration that goes into when and whether to file an IPR. I think another one is the age of the patent. Ideally, to file an IPR, it needs to be a younger patent, which I think the Patent Office has signaled is basically within 6 years of its issuance. If it's older than that, there's this notion that the patent owner has had the patent for so long that their expectations and its validity are settled, and so discretionary denial may be warranted. The last one I'll mention, and this is from the proposed rules, is if there have been earlier failed challenges to the patent, that's whether at the district court, in a reexamination, IPR, or even the ITC, that can be a situation that you need to consider before filing an IPR, because it could potentially lead to discretionary denial. Of course, with all of that, there are still other routes. One thing that we're currently looking at is whether these limitations are really only for IPRs. Like, what about a PGR, which is it's like an IPR, but it's got to be filed within 9 months of a patent's issuance. Maybe those would be viewed more favorably with respect to the trial timing, for instance. The administration has signaled that they do have a preference for PGRs. That hasn't played out yet. And then, of course, the other option, which we've been doing a lot of recently, is an ex parte reexamination.
Right. And you mentioned discretionary considerations. I'll also note that the October 17th memo stated that if institutions is denied, it'll just be via summary notice. So unclear if it'll be on discretionary or merits or something else. It'll just be one of those summary notices. Does anyone else on the panel have anything to comment on this recent October 17th memo from the Patent Office and proposed rules?
Yeah, and for the audience, the Patent Office, helpfully engaged in a webinar later. It was earlier, a couple days ago, or even yesterday. And by the time you're watching this video, and whenever you do, just know that all of these things are archived on the Patent Office's website, so you can rewatch the webinar. But the basic sort of explanation they gave was that there's going to be, three outcomes, possible outcomes on this new format of institution decisions. The first one, which they've signaled is going to be the one most frequently used, is a summary notice of either institution or denial, sort of a thumbs up or a thumbs down with no explanation. And that no explanation will also include, if it's a denial, for example, whether that denial was based on discretion or the merits. Second, the other option is that the director could weigh in and actually write a decision along with reasoning, but that will only occur when there's novel, important, factual, legal, or policy issues. And in that scenario, the director may address discretionary or merits-based issues. And then finally, in some cases, the director will refer it to a panel of 3 PTAB judges, which was the norm prior to the director's new rules. And here, this would be for fact-intensive issues. And then finally, the last note to recall here is that this is all for what happens at institution. If your case is instituted, then the trial will be conducted by a 3-member panel of PTAB judges, just as before.
Great, thanks, Roshan. And that's the piece we'll be focusing on today for most of the webinar is if you get instituted. I want to turn back to timing briefly, and this is with reference to slide 14. And Patrick, I'll turn to you. How do the presence of a declaratory judgment or the filing of a declaratory judgment action affect petitions at the PTAB?
Yeah, so you're not able to file an IPR or a PGR if you have filed for a declaratory judgment at the district court level. But for the most part, this is form over function in that, if you want to file a DJ action at the district court level, you simply file it for non-infringement. And then the patent owner is going to file claims of infringement as counterclaims. And then you can assert invalidity as a defense to those asserted infringement claims. So you can get to the same spot. You just have to be careful with the manner in which you approach it.
Great. So, Roshan, I'll turn it back to you. And let's say someone files a petition for IPR or PGR, and what are some of the ways that can impact the district court litigation?
There are several ways in which an IPR or PGR can affect a district court litigation. The one that is most interesting is a stay. So district court judges recognizing that the claims at issue in the case may be modified or canceled through an IPR process, find it an efficient use of resources to stay the case pending the IPR. This practice depends on jurisdiction. The Texas jurisdictions that are some of the most popular patent litigation jurisdictions, like the Western and Eastern districts of Texas, lean against staying unless every single claim that's at issue is going to be challenged, and that the timing of the IPR is well before the trial that's happening in that case. And that's just a scheduled trial. Other district courts, for example, those in California, are more apt to stay, and in fact stay sooner. So some courts will stay a case from when a petition was first filed. Others will wait to an institution decision. Another issue that comes up with respect to how an IPR can affect a district court litigation is that the positions of the parties on what the claims mean get more fully fleshed out sooner, typically in an IPR or PGR, than they do in district court litigation. In district court litigation, after a period of discovery, a court will set due dates in which briefs regarding the meaning of a term, so-called Markman briefs, and then a hearing on those issues is set. But at an IPR, the petitioner and the patent owner fairly quickly have to set forth what they think the claims mean and how they distinguish them from the art that's at issue in the IPR or PGR itself.
So Roshan mentioned that whether or not a court will grant a stay can vary with the jurisdiction. But Patrick, turning back to you, and we're on slide 13, what are some of the factors that courts typically look at in deciding whether or not to stay a district court action pending review of a patent by the patent office?
I think that's exactly right, as Roshan was saying the analysis is identical from district court to district court, but particular courts or judges are going to come up with radically different conclusions, just depending on how they run their courtroom, and often just the speed to trial for their particular courtroom. But the three main factors are the status of the district court litigation, right? The closer you are to trial, the further you are through that process, the less likely it is that you're going to get a stay. So the filing of a post-grant review early in the litigation and a slower trial date are going to be factors that make it more likely you'll get a stay. Also, as Roshan had mentioned, if the results of the post-grant proceeding are going to affect the entirety of what's at issue in the district court litigation, it's more likely that the stay is going to be granted. But if, for example, you're going to trial, there's 3 patents, it's just one product set that's being accused, and only one of the patents is subject to one of these post-grant proceedings, you're less likely to get institution. If, on the other hand, success at the post-grant proceedings, success in the IPRs wipes out all of the patents at issue, all the claims at issue, court's going to be more likely to stay. And then the last factor is whether it be unduly prejudicial to either party, and sort of whether it's being perceived as being used as for a tactical advantage. And that factor's always sort of struck me as odd, because it's always going to be prejudicial to one party. It's always going to be a tactical advantage to one party. But I think what it really means is there actual valid support for this being an efficient use of judicial resources, or is this just gamesmanship? And it's always going to be gamesmanship, but if it's also an efficient use of judicial resources, then it's gamesmanship we approve.
Let's turn to looking at it from the opposite direction. And Jeremy, questions over to you with regard to reference for our audience to slide 12. Are there any disadvantages to litigating validity at the PTAB compared to in district court?
Absolutely. Thanks, David. I guess the first thing I would say, a disadvantage to at least seeking to litigate at the PTAB right now touches on what we discussed earlier, and that's the non-insignificant risk of discretionary denial. And, as Roshan mentioned, the work that goes into an IPR petition, it can be, a couple $100,000 to put together, and the filing fees are like $50,000. And if it gets discretionarily denied, I guess some of that money is sort of wasted, even though maybe the invalidity work can be leveraged at trial. But I think that is a big potential disadvantage. But beyond that, once you do get instituted, I think the biggest disadvantage is the first one on the slide, which is estoppel, because once an IPR reaches final written decision, the petitioner is going to be estopped. They can't re-challenge the validity of any of the claims on any ground that they could have raised in the IPR. For the IPR, that's prior art and printed publications, under anticipation or obviousness. It's actually this estoppel gets even scarier for PGRs, because PGRs you can raise a lot more challenges, and the estoppel effectively concludes your invalidity case more or less. To that point, I should have made clear that this estoppel applies not just to the patent office, so you can't re-challenge the claims with another IPR or an ex parte reexamination. It also extends to the parallel district court litigation. So you're not going to be able to challenge if you have an IPR, you're not going to be able to challenge the validity of those claims at the district court under 102, 103, using printed publications. Another potential disadvantage on the slide is IPRs, PGRs. The whole point was to be an efficient alternative to litigation, and so they're fast paced, right? 1 year from institution to final written decision. Absent exceptional circumstances, you can get 6 more months, I think. And so the briefs are word limited, and the proceeding is very fast paced, and so you're not going to have as much of an opportunity to build a record. So that could potentially be a drawback. Next on the slide, very limited opportunity to present true testimony. I've actually never been involved in a case where there has been live testimony. I know that that's an option, but 99 to 100% of the time, testimony is just presented on the papers, right? You put in declarations, and there is cross-examination of the declarants, which is live, but ultimately it's just a transcript of the cross-examination. There's going to be no direct or cross in front of the panel. And so if that's something that would give you an advantage in your case, it's not going to be available in the post-grant review process. And then another potential disadvantage, patent owner can file a motion to amend. They can amend their claims. As a practical matter, I think it's very hard for a patent owner to have success amending their claims before the PTAB, because it's an adversarial and likewise fast-paced process where both sides are gonna be addressing the patentability of any proposed amendments, and ultimately a panel of patent-savvy judges is going to decide whether or not those amended claims are valid. And that panel at this point has already decided that the unamended claims, more likely than not, depending on where you are, what kind of proceeding you're doing, are invalid. So, I mean, it's something to keep in mind. They can amend their claims. I think as a practical matter, it's a pretty tough route for a patent owner to try to take.
Great. So I want to shift gears and talk about discovery at district court and the PTAB and be able to compare them. And before we get to the PTAB discovery, just at a high level, Patrick, and how broad is discovery in district court litigation?
We generally think of district court litigation discovery as being very broad, but it's certainly not unlimited. There's 2 main criteria for discovery at the district court level. The requested discovery, it has to be for obviously non-privileged subject matter, and it must be related to one of the parties' claims, right? A claim or defense. And then secondarily, the burden of providing that discovery must be proportional to its sort of probative value, right? Or the needs of the case. So there's a little bit of a balancing act, but anyone that's been involved in district court litigation knows that it's a pretty broad standard.
And with that in mind, and I guess by way of compare and contrast, moving to slide 22, Roshan, what kind of discovery is available in PTAB trials?
So in general, PTAB trials are much more streamlined and focused, and that principle applies to discovery as well. On the slide, we can see that there are four, if you will, buckets of discovery that is typically at issue in PTAB trials. The first is mandatory initial disclosures. These are sort of routine descriptions of what co-pending district court litigations may be at issue or other facts about the patent and whether it's been adjudicated before. So fairly low and not really an issue in which, a party would propound discovery requests on another. Then routine discovery are things like if you submit a declaration in support of your petition or in support of your patent owner responsive brief, then it is routine to allow for a deposition of the declarant. And then finally, there's additional discovery, which there are a whole set of factors governing whether additional discovery is allowed. And there, the types of district court discovery procedures that people may be used to, such as interrogatories and document production requests, and even deposition requests are contemplated, but again, seldomly used. And unlike the broad standard in district court, you have to really show that this is important and necessary for the case, as opposed to what some like to call a mere fishing expedition. Then finally, the PTAB trials involve an oral hearing at the end with 3 PTAB judges, and a party or the judges may ask for live testimony to be presented by those who have submitted declarations in the case.
But again, that last one, the live testimony, I also, like what Jeremy, haven't seen live testimony actually be used. They just look at the transcripts. Roshan, have you ever seen them ask for live testimony? Yes, it's in the rules.
No, we've not seen, I have not been in a case in which live testimony has been there. We have, to give you an example, though, of some of the exotic situations where live testimony may come in, is an inventor can submit testimony that indicates that they invented and were diligent in working on their invention prior to the prior art date. And there have been times in which live testimony is helpful there because sometimes you really just have to judge the credibility of the witness because not everything is corroborated with documentation. So that's an example in which I believe live testimony was at least contemplated, if not have done before.
Great. So let's turn to that third bullet point, additional discovery here on slide 22. And I'm going to move us to slides 24 and 25 together. Jeremy, what is additional discovery at the PTAB? How is it done and what is it?
Sure. So at the outset, it's discover other than mandatory or routine discovery. So discovery that's just not automatically provided for by the rules, because that's probably not too helpful of an answer. For some context, I've seen requests for additional discovery come up when litigating certain issues. One would be real party and interest issues. And in those disputes, the parties are trying to figure out who, other than the petitioner, let's say in an IPR, is driving the proceeding or benefiting from the proceeding. I've also run into additional discovery issues with respect to secondary considerations, and that's where evidence regarding like commercial success of a product can weigh against obviousness of patent claims covering the product. And so both those types of evidence, typically that evidence is not going to be public. It's going to be in one of the parties' control, and it may not be fully presented through the typical IPR process, right? The usual briefs and other mandatory routine discovery. And so that's when you need additional discovery potentially to obtain that kind of evidence. As far as how you get it, you can just agree to additional discovery. We've done that. And then if you can't reach an agreement, you have to ask for it. And the process is typically you send an email to the board seeking permission to file your motion for additional discovery. If they give you permission, because it's not a motion you can just file because you want to file it. You have to get permission before you even file the motion. And if they grant it, then you'll get to take your additional discovery. With that said, and this was mentioned earlier, PTAB trials are supposed to be fast and efficient, so additional discovery is fairly limited, and you have to show that receiving the additional discovery is in the interest of justice. It's a practical matter. You have to already be in possession of some evidence showing that your additional discovery is going to be useful, or you're probably not going to get it.
So, Chairman, you want to cover the different standards? So for PGR and IPR, what do you need to show to get that additional discovery?
Yeah, so in an IPR, which is the most popular post-grant proceeding, it's a set of factors that get applied to determine whether or not you're going to get the additional discovery, and the ultimate standard is high. It's interest of justice. And as this slide shows, in PGRs, the standard is actually a little lower. You only have to show good cause. I'm actually not aware of, I'm not sure whether in practice that means it's easier to get additional discovery in PGRs, but at least the standard per the rule is lower. And maybe that's because PGRs have so many more grounds and there can be so many more issues evaluated in a PGR that there may be more of a need for additional discovery than in the more limited IPR. But that's just my speculation.
So the standard case that they talk about is Garmin versus Quozo, sometimes abbreviated as the Garmin factors. Roshan, can you walk us through those Garmin factors and how they're used for additional discovery? And for our audience, I'm on slide 26.
Yes. So as Jeremy mentioned, additional discovery is something the parties can negotiate about. But then if there's an impasse, then a motion is filed, and now these factors come into play. So the first one is about discovery must be more than a possibility and a mere allegation. So this is sort of the fishing expedition moniker I used earlier, where the purpose of additional discovery is not to go see if there is an issue, but after knowing that there is an issue, how do we demonstrate that proof of it? So, for example, if you were concerned about real party and interest, you can't use additional discovery to try to learn about particular contractual relationships, just hoping that there might be a random contractual relationship with a particular other company that implicates real party and interest. Instead, you have to already credibly understand or know that such a relationship exists. Second, requests cannot alter the trial timing under the pretext of discovery. So the streamlined impact of, or the streamlined nature of these proceedings are actually governed by a statute, unlike district court trials where there is no statutory limit on how long a trial can take. So in particular, after a trial has been instituted, a PTAB trial has been instituted, you have, in most cases, 12 months by statute to be able to reach a conclusion. And so discovery requests can't be used to delay that process. Third, similar to district court subpoenas, third-party subpoenas, requests should not seek what the requester themselves can generate. I think that's pretty straightforward. Fourth, the request should be easily understandable. The way that this actually plays out is what I have seen in the past is you get requests for production that are voluminous, that look a lot like district court litigation, and the judges typically want to just understand at its core, what are you really looking for? And they don't appreciate seeing vaguely worded, 20 different alternative ways of expressing what you're looking for. And then finally, the request must not be overly burdensome to answer. That overly burdensome also takes into account the size and sophistication of the other party who's receiving it. So, for example, if you have a small company who is the petitioner, or a solo and patent owner who is the patent owner, discovery request must be tailored to that as well. And again, I think a nice lodestone is what it looks like for in third-party subpoenas in district court litigation. And as the last bullet notes, because of this, and because people typically bring their district court litigation experience into PTAB trials, a lot of additional discovery motions are denied or only granted in part. In fact, that's been the most that I've seen in my practice.
Yeah, same here on that. All right, so let's assume a party gets some documents at the PTAB and wants to then use them in district court, or the more common scenario, a party has documents that were produced in district court and then wants to use them in the PTAB. Patrick, can you tell us about the cross use of documents between PTAB and district court?
Yeah, as I had briefly mentioned before, documents can be used across the two different types of proceedings. But one of the limitations would be subject to any protective order that's in one or the other. And a key component, particularly in IPR trials, is that the district court litigation will often have a protective order that includes a prosecution bar. So it prevent any of the attorneys that have access to the confidential information that's disclosed in the district court litigation to be substantively involved in prosecuting patents, typically in the same area of technology. And that creates a limit, for example, if you were going to amend your claims in an IPR, right? You're not going to be able to use that confidential information from the district court litigation to inform the scope of claim amendments or things of that nature. It's important to make sure that you recognize how the protective order in each, whether it's the PTAB or the district court litigation, how it's going to affect the sharing of documents, but also the ability of various attorneys to be involved.
I want to follow up on the comment about protective orders, and Roshan, I'll ask you. Is it possible to obtain similar protection to district court protective orders when litigating at the PTAB?
Yes, there is protective orders are contemplated and considered routine by practitioners. In fact, the trial practice guide issued by the Patent Office has a specific sections on protective orders and even has a sort of a template protective order that can be used that most parties use as a starting point and sort of only redline in certain circumstances.
So I want to go back to something Patrick mentioned earlier about how it didn't used to be this way, but at least now the PTAB and district court have the same standard in the Phillips standard when construing claims. And Jeremy, I'll turn it over to you. Can you tell us the effect that a district court claim construction order has on PTAB proceedings, and conversely, if the PTAB judges construe claim terms, what effect that has on district court proceedings?
Sure. So starting with the first scenario where we have, let's say, a district court claim construction, under the 2019 trial practice guide, the PTAB was and still is required to consider that construction, and it could follow it in appropriate circumstances. I think per a recent September 16th, 2025 memo, and I'd love to get the other panelists' thoughts on this, the board is now required to do more. And as I understand that recent memo, if the board doesn't want to follow the district court claim construction in this example and wants to reach a different construction, they're going to have to explain in detail why their different construction was warranted. And so I think now, beyond just address it and follow it in appropriate circumstances, it seems more like follow it, and if you really don't want to, you need to give a detailed explanation as to why you didn't follow it. And so I think going forward, we may see more deference to not just district court constructions, but even ITC constructions. That's how I think that's going to go. As far as the other way around, I'm not. The district court, if you have a PTAB construction, is not going to be bound by that construction. The parties can advance it. I'm sure the PTAB decision articulating why that construction makes sense could be put before the judge, and maybe it's persuasive, but the district court judge is definitely not going to be bound as much by the PTAB construction as the PTAB judge may be by the district court claim construction.
Yeah,
think that's
and I'd
right.
add that this deference, or that you mentioned, Jeremy, or the PTAB, if they're going to have a different view on claim construction than district court, they really have to explain the reasoning. That applies even if there were different parties. So if the plaintiff and a defendant one have a district court case that concludes and there's a construction, and then plaintiff sues defendant two, and defendant two files an IPR, that would apply as well. Is that, does the panel see it the same way?
Yeah, I think it's similar, and I think in practice, most practitioners, whichever side of the V you're on, typically don't want or understand, even prior to the recent guidance, to tell a panel of three PTAB judges that the district court judge got it wrong. What typically happens is a refinement of the construction, or addressing an issue that wasn't squarely addressed by the construction. That being said, the memo, I think, makes it clear that PTAB judges, it sort of made it formal, effectively, that PTAB judges should be giving deference to district court constructions, and really in only extraordinary circumstances alter it. I think what remains to be seen is if the common practice now of refining a construction as opposed to altering or changing it, whether that also will fall under sort of a stricter scrutiny. Whereas I think PTAB judges, up until this most recent memo, have felt fairly free to refine a construction to elucidate an issue that perhaps was still obscured because the issues were different.
So Patrick, turn to you. So how can these overlap in claim construction between district court and the PTAB in this effort to harmonize one with the other be used strategically to improve global litigation positions?
So particularly because there's a limited scope of validity attacks that can be made at the PTAB and an IPR, and because they're often staged at different points in the life cycle of the district court litigation versus the PTAB litigation, I've seen it as a trap working either direction, where arguments made at the PTAB and an IPR based on a subset of the patents or publications that may be used in a challenge in the district court litigation, lead one of the parties to make, short-sighted arguments or statements about scope of the claims or scope of the prior art that, negatively impact arguments that would have been made at a later date at the district court trial. Again, this goes back to the point I briefly had mentioned before, that all of the arguments and, all of the actions that you're taking in one of these proceedings, you need to be mindful of what you expect to want to argue, at a later stage in a different proceeding.
Russia, one of the, I think, considerations you mentioned earlier on when litigating at the PTAB is the effect of estoppel on further proceedings. Can you elaborate on that, such as when estoppel becomes effective, what the scope of it is, and what people have been doing to try to escape the reach of estoppel? And I'll go to slide 15 for that, for our audience.
That's right. So as I mentioned, the statutory framework, Congress intended and understood that if the PTAB was going to be effectively be used as an alternative to district court litigation, as opposed to just giving someone who wanted to invalidate the patent sort of two bites at the apple, they created estoppel that applies to a district court litigation that the petitioner was involved in. The estoppel only kicks in when there's a final written decision. So that's the first issue. The scope is that a petitioner cannot raise invalidity arguments it did raise or could have raised in the IPR. So coming back to what prior art arguments can you use in an IPR, it can only be under the sections 102 and 103 of the statute, so anticipation or obviousness, and it can only be based on documents and not, for example, as we discussed, system prior art. Also, section 101 and section 112 and validity-based arguments are not implicated by this estoppel. And then finally, what savvy litigants have done is to sort of look at the landscape of prior art that they have and decide whether they do have system art. And then those litigants have to be careful about asserting in the IPR documents about the system, or similar enough documents about the system in the IPR, because there has been estoppel held where you say, well, in the district court, I've got system art, but in reality, the system art works in the same way and was implicated by the documentation you provided in the IPR. So litigants have been careful to try to keep those two separate. Another argument that has been used with varying levels of success is that a particular piece of prior art was found very late in the litigation, and it basically took moving mountains to even try to find it. And so thus it reasonably could not have been raised in the IPR because the petitioner didn't even know about it. But in order to prove that, you really have to get into things that people typically don't get into, which was, what was your prior art search process? How did you end up uncovering this hard to find piece of prior art in the first place?
And so, Jeremy, in terms of what we've seen at the PTAB with discretionary denial over the last few months, and some of the new rules that they've proposed, how has that changed the timing or scope of estoppel? Jeremy, mute.
Thanks, David. Sure. So I think with the current discretionary denial landscape, and I think we've discussed this earlier, the director, I guess, who's deciding institution now, right, is going to want to see a stipulation that effectively causes estoppel to take effect, not at final written decision as it does in the statute, but at the institution phase. And so what a party will do is put in a stipulation that says, if this proceeding is instituted, I will not pursue invalidity at the district court under any ground I raise in this IPR if it's instituted or could have raised, right? So it effectively, it has the estoppel effect. I don't know that I would call it estoppel, but it applies sort of at the institution phase. So earlier, and even up until the recent discretionary denial decisions, we had Fintiv, which had the trial court timing that we touched on, and parties were making these sort of stipulations. I think in the recent landscape, it's becoming clear that, well, at least to me, that it's sort of a requirement, because the PTAB views these trials as an alternative to litigation. And if you're going to choose the PTAB to litigate validity, that's where you're going to make your validity case. And they don't really want you doing sort of the same thing over in the district court.
Let's talk about settlement. Patrick, can PTAB trials drive settlement between a patent owner and a petitioner?
Oh, certainly. I've seen lots of movement towards settlement caused by the leverage from IPRs and these other PTAB proceedings. Obviously a final written opinion that invalidates the patent is going to create a tremendous incentive. The case is gone if that were the only patent in play, or if each of the patents were affected, but certainly can affect the damages scope and all of that might be in play. I've seen partial settlements as well, right? Like in one of my cases not long ago, we had asserted 4 patents. IPRs were filed against each. And when looking at them, you know, it wasn't going to be efficient to bring all 4 to trial anyway. One of them was sort of the odd man out, and it didn't make sense from a risk perspective, or certainly from a cost perspective, to keep that patent in place. So, you know, it immediately forced us, and I think positive for both parties, to pull that patent out of the district court litigation, settle it away. But yeah, I think that, you know, you certainly have the costs that are associated with it, the risks that are associated with it, the estoppel that we've talked about, you know, the traps for arguments that might occur in one affecting the other. So I think anytime that there's a post-grant proceeding, it's a great opportunity, you know, maybe not at the stage of filing, but certainly at the stage of institution, and then through that process up to the final written decision.
And also for the benefit of our audience, the PTAB doesn't have to terminate the case just because the parties want them to. If it's pretty far along, the PTAB may just go to a final written decision, and the parties do need to request permission to settle and terminate the case. Let's move on to a different aspect of the proceeding, and that's a motion to amend. So patent owners can sometimes amend their claims in a proceeding. Let's go to slides 18 to 19, and I'll turn it over to you, Jeremy. And this is a kind of a complicated graph or timeline, but can you simplify it for us? What's the process for amending claims at the PTAB?
Sure. Thanks, David. So looks like we've got our motion to amend timeline here. And as it shows, a patent owner can file a motion to amend when they file their patent owner response. Actually, they could just file a motion to amend alone if they wanted to. A motion to amend is going to include what are called proposed substitute claims. And if I hadn't mentioned, they can be, this motion to amend process can be contingent. So it can be, hey, we think that our existing claims are patentable as explained in our patent owner response, but should you disagree, here's our proposed substitute claims in a motion to amend. Certain requirements have to be met in the motion to amend. The number of proposed substitute claims is limited to the number of claims that are challenged. So it's sort of 1 for 1. You can propose 1 amended claim for each challenge claim. There is no broadening. There can only be narrowing, and you have to make a showing of where your proposed substitute claims are supported in the as filed application, and you know, any priority application. You have to establish that as the patent owner in your motion to amend. Once you file it, the other side, and I think this is one of the biggest drawbacks of motions to amend, is going to take a shot at it, right? They're going to reply to your patent owner response, but they're also going to likely oppose your motion to amend. And in opposition, and this is interesting, even if you're in an IPR where it's typically anticipation and obviousness, they can challenge your proposed amended claims under, I think it's just about any ground of invalidity. So there can then be subject matter eligibility issues, enablement issues, written description issues, and you know, the expert's going to opine. They can use new prior art. They don't have to use the prior art that was in the petition, right? This is like a mini IPR that gets kicked off within the IPR in a very short time frame. And so once the opposition comes in, patent owner, if they're taking advantage of certain pilot programs, can seek guidance from the board, and the board can actually give them an idea as to whether they're going to have success with their motion to amend or not. And patent owner can choose to file what's called a revised motion to amend, right? So they can try again, basically. And then we're going to have an opposition to that. So you can see there's a lot of moving parts here. And then the petitioner can oppose that, again, on all the grounds of unpatentability, even with new art. And then ultimately what happens is the PTAB decides first in the final written decision whether the claims as is are shown to be unpatentable or not. And if they are, they'll decide whether to grant, at least in part, the motion to amend based on the motion, the opposition, reply, what have you.
Jeremy, if a patent owner is successful in amending the claims, what happens to the original patent?
So ultimately, at the final written decision, after the final written decision, there's going to be a trial certificate. And if the original claims were found to be shown invalid, those are going to be canceled. And then they're going to be replaced, I understand, with the proposed substitute claims. I don't think the proposed substitute claims become new claims. I think they actually substitute per their name. But if the other panelists might understand the intricacies of how the claims actually end up. But ultimately, invalid claims are canceled in the trial certificate. And if you had successfully amended claims, they're going to become part of the patent. It's the same patent, unlike a reissue where you get a new patent. It's still the same patent. It just has its claims changed based on the motion to amend in the final written decision.
So Roshan, with the few minutes we have left in the hour, and I'll turn to slide 21 here, especially in view of the recent changes at the PTAB with the discretionary considerations, what are some other options or alternatives to IPR and PGR proceedings, and also whether or not claims can be amended in those proceedings?
Thank you, David. I think it's important to note that in district court, you cannot amend your patent. They can cancel claims, but they can't amend them because the district court, any amended claim has to go through not just a prior art scrutiny, but all the other requirements of the patent office, and district court judges aren't equipped for that, which is why, from a policy perspective, only the patent office can amend or add or claims to a patent. So that being said, there are two other processes that can be used in the patent office for amending or changing claims. One of them is ex parte reexamination. Those can be filed both by anyone, including the patent owner themselves. You can choose which subset of claims you want to use to challenge or to change. Ex parte reexamination has to be based on prior art, and so the patent owner, if they want to correct a mistake, they can't use ex parte reexamination if there's some typographical error. Instead, the other option there is the reissue process. Both have their pros and cons. Reissue can be time consuming, and it's essentially a surrender of your original patent for effectively a new original examination of your reissue application. And other parties can participate in reissue. So they can watch what's happening in the reissue prosecution, submit protests to the reissue, including prior art-based protests. So it can turn into somewhat of an inter partes process without any of the estoppel or other issues that come into play in an IPR. However, reissues can only be initiated by the patent owner. So in some sense, the patent owner sort of picks their poison. Ex parte reexams can be filed by anyone, including someone that's in district court litigation. They have to be prior art based, but once they are filed in the normal course, the requester is no longer involved. It's just the patent owner and the examiner. There are no estoppel issues and no real party and interest issues. So it's only a minor subset of cases where that even comes up at all. And so increasingly, companies and litigants have looked to the use of ex parte reexamination as an alternative to inter partes review. It's not really a trial process, as I mentioned, but I had a chance of writing an article that sort of compared the success rates, and the success rates in general of ex parte reexaminations and inter partes reviews were very close. The risk, of course, and the benefit to the patent owner is that it's much easier to get amendments through ex parte reexamination because you're really just talking with the patent office and with the examiner.
All right, well, that takes us to the hour. I'd like to thank our three panelists, Jeremy Albright of Norton Rose Fulbright, Patrick Richards of Much Shellist, and Roshan Mansinghani of Unified Patents. Thank you all three for joining us, and thank you to the audience as well. That concludes our webinar.